Hey, good morning, everybody. It's Tuesday, and if you're waking up late, you're just now seeing, presumably, that Donald Trump took 51% of the Republican vote in the Iowa caucuses. Ron DeSantis had a little bit more than 21%. Sticky Nicky got about 19%.
Sticky Nicky, boy. I like that.
And Vivek got 8% and then dropped out, throwing his support to Donald Trump. Significant moves. Mike, I wasn't sure what was going to happen in Iowa. I don't trust polling and pollsters. I think people have a tendency to say one thing and do another, and so I wasn't sure that Trump would pull it out, but he did. And so now, the Republicans are scrambling. I don't know what will happen with DeSantis and Haley. I don't know how many of the people that Ramaswamy of his voters will actually go to Trump on his recommendation. But the all eyes now turn to New Hampshire. The first primary will take place in New Hampshire next Tuesday, the 23rd, and we'll wake up next Wednesday to a race that has fundamentally changed. DeSantis left Iowa, heading to South Carolina, where a lot of delegates are at stake, and he'll spend part of today in South Carolina, part in New Hampshire. Candidly, I was relieved to see that Trump won. I mean, the more I think about Donald Trump, I want to repeat what we said yesterday. The more persuaded I am that he's not the end of democracy. He's not an existential threat to America. He's a throwback candidate. And I'm not talking about his desire to make America great again. I think Donald Trump reflects the politics of an era that was suspicious of government. And I'll repeat what I said yesterday. He is popular because he's the kind of guy who doesn't think that government has the right answers, and that when government can ask the right questions, and that when those questions are asked, should insist that we give the correct answers. People are tired of orthodoxy. People are tired of being told how to go along. People are tired of government being seen as the well from which everybody can draw whatever it is that they need. And Donald Trump suggests a cynicism toward government that used to be the American way. I mean, his rhetoric, I'm looking at what you've got on the screen there. I don't know what to make of that. Trump easily wins Iowa caucus in historic landslide, urges unity to straighten out death and destruction. Well, Donald, it would always be a good idea to eliminate death and destruction from the human condition. But I think that undermines the point I was just trying to make about you. Government isn't the answer, and more government isn't the solution, not to the problems that bedevil people, the kind of people who would vote for Donald Trump. So,
Well, here's the breakdown for the Iowa caucus. 51.1% for Trump, 21.2% for DeSantis, 19.1% for Nikki Haley, 7.7% for Vivek, who, as you already said, pretty promptly ended his campaign when the results were, for the most part, in, which signals that he was being truthful when he said, well, first of all, I'll say I'm disappointed. And it's because of one thing, and it's his promise to stay in the race, to run the whole race. But that notwithstanding, I understand that he is an entrepreneur and he is a successful capitalist. I think he probably had some internal metrics that he and his team had agreed on, and he held the line when they didn't meet those metrics. And so, to throw additional money after failing to reach whatever critical mass they had set for themselves, I think is wise. It shows great restraint and discipline, and especially considering how aggressive of a campaign he's been running, it's tough to argue with the decision, right?
No, I mean, he, as you pointed out yesterday, Vivek had 400 plus appearances in Iowa, appearing in all 99 counties, and he worked the caucus as hard as any candidate in recent memory. And to not even be able to crack a 10% threshold, if there was an internal metric, I can imagine that was the number. But to fall behind DeSantis and Haley by double digits in each instance suggests that it just wasn't there for him this year. I was surprised that DeSantis did as well as he did. It may be that I've got a that I've got Loomeritis, and that I look at him through Laura Loomer's eyes and view him as a duplicitous loser. But I'm surprised that he got 21.3% of the vote. What accounts for that?
It was 21.1%. And the New York Post article that I have on the screen actually goes into some of the subgroups of voters. They were saying that, Trump obviously did well with rural Americans, rural voters, but surprisingly, he also did extraordinarily well with suburban voters this time around in Iowa, which I think he's struggled with and has been a weak point in his campaign. For DeSantis and Haley, I'm not sure. I think that there is an amount of money that they're spending. I think I told you that Haley had spent north of $68 million on TV buys in Iowa for the Iowa caucuses. I think I think DeSantis, according to that audio leak, and maybe it was according to the audio leak or otherwise, but DeSantis had spent north of $50 million. So I think at a certain point there's an inflection point that money can get you to in terms of name recognition and what's there. I also am sort of ignorant to the Iowa caucus process. I know that there are members of the caucus and they go and they cast their ballot for a specific Republican candidate. So I think we're dealing in, the mid 150,000 potential votes cast out of all those caucus goers. But one thing that I've been reading and I want to chase down a little bit is Vivek's performance with the younger demographics and first-time caucus goers. I was reading early that the figures were showing that he was outperforming all the other candidates in that respect. And by a sheer numbers game, I don't expect that was the end result. But I am excited to sort of look at where he goes in the future, and I have great gratitude for what Vivek has done thus far.
Well, obviously, he is the candidate to watch in years to come. He's all of 38 years old. He's got 5 candidacies left, 6 candidacies left in him, 7 if he wants to continue to play the game into his senescence. So, thank you, Vivek, for putting your thoughts and ideas out there and laying down a marker and pointing to a direction where we can go in the distant future. As for 2024. Things are heating up. Dawn points out that evangelical leadership in Iowa is big behind DeSantis, big factor. Now that may be. I'm not sure that that I understand that. I think the evangelical vote is big in Iowa in general and is big for the Republican Party. And for that, candidly, I am grateful. For those of you who are always looking for something to read. I'm reading a fascinating history of American evangelicalism right now. So fascinating that I can't remember the title, but I want to get you the title for it and give you a recommendation. It's called Fundamentalism in American Culture by George Marsden, Marsden. We'll post it on the newsletter in our what we're reading category. It's the 3rd edition of the book. And, if you don't understand fundamentalism, if you don't understand the evangelical movement, you don't understand a good part of middle America. These are people who believe that the Bible is divinely inspired, that Jesus rose from the dead, and that there is a spiritual answer to every question, and that it is reflected in religious experience. And that's been a significant part of the American experience.
This is another one we should probably put up there as well. Norm, have you read Summer for the Gods?
Yeah, Summer for the Gods is an account of the Clarence Darrow trial, the Scopes Monkey trial back in 1923. I think it was. I can't remember the name of the town in Tennessee. And it's another great period piece about ideas that gripped Middle America. William Jennings Bryan was some couple-time presidential candidate, faced off against Darrow. Bryant won the trial, but Darrow won the battle for public opinion, and Bryant died shortly thereafter. He took the stand, which would never happen. A lawyer would never be permitted to take the stand in an ordinary trial. But when Clarence Darrow cross-examined him about the literal truth of the Bible, Bryant had to give answers that didn't withstand the test of common sense. And it reminded me of the old church father Tertullian, who once said, I don't believe that which is absurd. I believe because it is absurd. the world is a fact that needs accounting for, and there is no rational explanation for the origin of space and time. There are just responses rooted in faith, and so there is a faith tradition in the United States that looks at the world as a spiritual drama, and that has rallied behind Republicans in recent years. We'll see where it goes
Yeah,
in
and I love
2020.
that last part of what you said, that it's rallied behind Republicans in recent years, but I think that historically, I think the Scopes trial was 1925, so it's a great historical perspective
Dayton,
on
Tennessee. Thank you,
yeah,
Julian.
yeah, a great historical perspective on how those political paradigms can shift to and fro over the course of history, right? Because we're talking about the American South. There was a time when that was almost universally democratic, as we would refer to it today.
So let's talk a little bit about what else is going on in Trumpville. Joe Tacopina uh, is reported to have, quote, withdrawn from representation of Donald Trump. Um, um, I want to talk a little bit about that because I want people to understand the mechanics of lawyering. That is one of our objectives here in Law and Legitimacy, is to bring an awareness of the world as lawyers experience it and manipulate it to public consciousness. Joe Tacopino is a 50-something lawyer, went to Quinnipiac Law School, a stone's throw from here, then went on to Manhattan, became a prosecutor, and has been a lawyer to high-profile people for many years. He swings hard, and he commands big fees, and he gets results, sometimes good, sometimes bad, which is the lot of all criminal defense lawyers. When Trump tapped him to help represent Donald in the case brought against him by Jean Carroll, and also to to help in the representation of the criminal case involving forgery of records, of public records. Yeah, I was kind of pissed off. It's like, hey, Donald, you got to call my neighbor. You didn't call me. But I was also kind of relieved because high profile clients are pains in the posterior. First, the world is watching, and every move you make is dissected by people who love or hate your clients. So you're either loved or hated to the degree that your client is loved or hated. There's a whole cottage industry of people who specialize in breaking my balls because of my representation of Alex Jones, and to them I say thank you for the space I occupy in your head. But when why did Tacopino get out of Donald Trump's cases, or why is he trying to get out? And I think this is what the public doesn't understand. A lawyer can only leave a client's case with permission of the court. Once a lawyer appears on behalf of a client, they are bound to that client in the court's eyes unless and until the court relieves them of that responsibility. So Tacopino doesn't have the ability to unilaterally withdraw from Trump's case. He can ask the court for permission to withdraw. And what sorts of things would support that? Well, now we may never know, because although he's filed a motion to withdraw, he's still bound by the attorney-client privilege with respect to Donald Trump. And he can't say, I'm leaving because Donald said, I'm leaving because Donald did, I'm leaving because Donald didn't. That might violate the privilege. So he can signal to the court the reasons for that, and there may be private proceedings where if Donald Trump contests Tacopino's leaving, the court has to decide whether Tacopino can in fact go. I suspect that Donald has had his way with Joe, and Joe's had his fill of Donald, and as with any of the scores of lawyers who've come in and out of Trump's team, he'll just fade away quietly into the sunset. But here are standard reasons why clients try to get out of why lawyers try to get out of a client's case. First, if a lawyer doesn't fulfill their or if a client doesn't fulfill their financial obligation to the lawyer can provide written notice to the client saying, you owe me X, and if you don't pay me X by such and such date, I'm going to move to withdraw. That's a permissible reason to go. It's not a pledge of indentured servitude for a lawyer to agree to represent a client. Second, if a client is trying to use the lawyer to commit a crime or engage in some other fraudulent activity, the lawyer can say, look, I signed up to represent you. I didn't sign up to commit crimes with you. I didn't sign up to engage in unethical conduct. I call this the Jimmy Hoffa rule. Remember mobster Jimmy Hoffa from the Detroit area. He disappeared. I don't recall the year. Somebody comes into your office and says, I got Jimmy Hoffa buried in the Meadowlands. I need your help. What kind of assistance can the lawyer provide? You can defend a client for their activities up until the moment they walked into your office. They can engage in the most heinous conduct possible, and your responsibility is to represent them if you can stomach it. What you cannot do is help them in the furtherance of unlawful activities. So in the Hoffa case, I buried Hoffa in the Meadowlands. The cops want to talk to me. I can defend you. Uh, Change the hypothetical ever so slightly. I can't. I buried Hoffa in the Meadowlands. We got to move him. Can you help me? No, it's that moving of the evidence that would create a problem for the lawyer. I doubt that's what happened in this case. A further reason for moving to withdraw is if the client's demands become unreasonably difficult for the client. What does that mean? You've got a client who won't follow advice. You have no client control. He makes impossible demands. He's impetuous. He calls you at all hours of the day and night, demanding the impossible. I can imagine that might be the case with Tacopino. And then a final and different grounds would be if the client's objectives became repugnant to you. Remember, lawyers have a duty of zealous advocacy, and that means you've got to be all in for a client. You can't fight for a client with one arm behind your back. I've only moved to withdraw on these grounds once or twice. I remember in one instance in a family case, a client who feigned a heart attack and fell on the courtroom floor, and they had to revive him and bring him back into the courtroom. And then every week was a drama, and the guy just didn't want to deal with what was coming. And so one day, the result was what should have taken 5 hours of work was now taking 40 or 50 hours, and it was just an ongoing drama. And one day I just had enough, and I said, "Judge, I move to withdraw." And the judge says, "Why?" I said, "I don't think my client's objectives are repugnant to me. I understand why he's fighting. He just has become repugnant, and I can't be a zealous advocate anymore." I agree, Mr. Pattish. You're gone.
I
And
have
so,
a alternate theory for you. And based on this
yeah.
Rolling Stone article, the quote out of the Trump campaign is that they've assembled the strongest, legal team that they've ever had, et cetera, et cetera. What can you say about co-counseling with attorneys that are all alphas, Norm? Is it possible that this is sort of a mutual agreement for Joe to step out? He's moved for withdrawal. They haven't opposed the withdrawal, and perhaps they just weren't using him in the manner that they thought, or they had gone strategically somewhere else. And he's looking at this saying, "There's too many cooks in the kitchen. I've got other things I could be doing."
Possibly. I mean, all trial lawyers are prima donnas. That's why you become a trial lawyer. I mean, I hate to nerd out on obscure books, but we've talked before about Harold Lasswell's classic in the 1930s called Psychopathology in Politics. Lasswell was an American political scientist, and his argument was that politicians are warped. That's why they put up with all the BS that's involved in politics. And you shouldn't expect a normal personality to be involved. And same is true of trial lawyers. We want to be where the action is. We want to be this focal point. We want to direct the show. So if you've got 6 directors and there's only room for one at lead counsel, that means you've got 5 people playing supporting roles, and there could be friction between the lawyers.
Yeah, it just seems to me. It seems clear to me that perhaps he didn't work on the initial E. Jean Carroll lawsuit, but he was working on the appeal. And then there's a second E. Jean Carroll lawsuit coming down that he's not attached to. I'm not sure that Joe Tacopino is attached to any other case, so it may be that perhaps the case in and of itself wasn't big enough. To your point, Norm, about him sort of being, he wants a bigger slice of that Trump pie with respect to legal defense. I don't know. This to me seems like, the mechanics of withdrawal are really important for the average, legal consumer to understand. I think attorneys have a huge burden there. But when it's client led, I think it becomes a little easier, especially if there's some sort of mutual agreement, and especially when you've got pedigree and experience and reputation to the degree that is in the same room when you have one such as Trump and Tacopino in the same room. So I don't know.
Well, maybe, but I mean, when the campaign says we've assembled this great legal team, I'm thinking, yeah, it's I can't even remember who's in, who's out, how many of them there are, who's leading it. It's a game of musical chairs, and people come and go at such a rapid rate that you get whiplash trying to follow it. So I'm not sure it's the greatest legal team of all time. That's the kind of thing that Trump would say. But he would say that if he didn't even have a lawyer and he was pro se. I'm the greatest lawyer there ever was, and I'm going to do it myself because I'm Clarence Darrow incarnate. And if I had cross-examined William Jennings Bryan, it wouldn't have taken him 3 days to die after trial. He would have died on the stand because I'm Donald Trump and blah 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 blah. So anyhow, farewell to Joe Tacopino. subpoena? Maybe.
Do I have your permission to pull up those? I think they're filed documents. I don't know that I need your permission. They're public records. So I'm gonna go ahead and pull those up for the next topic.
Oh, yeah. So let's let's switch over to the J6 prosecutions. I'm going to go out on a limb here and suggest to you that the next month might be a big month for January 6 prosecutions. What am I talking about? Well, the House J6 committee issued a report. Liz Cheney wrote a book. We talked about her book about the committee, and it was the committee's conclusion that Donald Trump was responsible for the events of January 6th, that this was a Trump-led, inspired insurrection. Hundreds of people have been convicted, more than 1,000 prosecuted. There are more prosecutions to come, and there are arrests almost weekly in this case. And federal prosecutors have focused on the Proud Boys and Oath Keepers, for example, in their claims of seditious conspiracy. That is, that there was an organized effort to oppose by force the authority of the United States government. But what prosecutors have not done yet is prosecute the missing links in this case. In other words, the House committee has suggested that Trump led it. Prosecutors on the ground have obtained convictions of the Proud Boys and Oath Keepers, but they've never and they've charged Trump, but not with seditious conspiracy. So there is this gaping hole at the heart of the government's J6 narrative. One branch of government is contending the president organized this and pressed it for nefarious purposes. Another branch has charged people on the ground with being the president's pawns, but nobody has been able effectively in a criminal prosecution to connect the president to the pawns or to connect the president's middlemen to the pawns. And there are a pool of middlemen who have yet been charged. Roger Stone, Alex Jones, Steve Bannon, Ali Alexander, some of the individuals who financed the events at the Ellipse on January 6th. My prediction is, and you look in recent weeks, Matthew Graves, the United States Attorney for the District of Columbia, was saber rattling the other day in a video talking about there being more prosecutions to come. And suddenly things have gotten very quiet among an otherwise chatty group of prosecutors in DC. And you get the sense that there's something about to happen. And my hunch is, as Jack Smith runs into one roadblock after another in the effort to prosecute Donald Trump prior to the November 2024 election, the Justice Department will become desperate and conclude that if we can't get Trump, we're going to try to make a case against one of these fictive middlemen, because I don't think there was a plan, but the government does. And so their hand is going to be forced. And what am I talking about with respect to roadblocks in the Trump prosecution? The Florida documents, the Florida state secrets case, Jack Smith can't seem to get around the court's determination to delay that case. The obstruction case in Washington, D.C. is tied up in the appellate courts right now, and certain issues involving presidential immunities are likely to end up before the Supreme Court. The New York State case involving forged documents, if that's got a trial date, I can't recall when it is, and it's unlikely to have any real impact on things. And so, and then you've got Fannie Willis and her love life, which now has hit a bump in the case, calling into question the integrity of that prosecution and possibly yielding delays in that trial schedule. It's unclear yet. There'll be a hearing either later this month or early next month on whether these seemingly libidinal improprieties have any impact on the prosecution. So if you can't get Trump before the election, if you can't tag him with a conviction that might inspire other elected officials to conclude that he's ineligible because he engaged in insurrection within the meaning of Section 3 of the 14th Amendment. If you can't stall or interfere with the election that way, then the next best thing for the Justice Department would be to dust off what I call these missing link defendants and bring a couple of them into court to prove that they were the connection between Trump and the people on the ground on J6. I wouldn't be surprised to see a new indictment or two come up because the Justice Department isn't getting what it wants. I believe that it does want to derail the Trump campaign, and the most effective way to do it would be obviously to attack Trump. But as these cases get bogged down in appeals and legal maneuvers, it's likely that they're going to have to go elsewhere, because the energy, the frantic desire to stop the campaign is almost an obsession. There's a piece in Politico this morning about a reporter who talked about talking to diplomats around the world who are so concerned, that they're betting against American democracy because of Donald Trump. I mean, where does this hysteria come from? One could argue that this isn't the failure of democracy; it's democracy in action, and that there are fed up, pissed off people who are mad as hell and don't want to take it anymore. And were pissed off in 2016, were pissed off in 2020, and are even more pissed off now. And they're going to come out and vote to Donald. When they do, that's we'll follow that in 2024. But in terms of the prosecutions, I want to focus and pivot a little bit quickly to it's a very interesting motion. I got to give credit to Condemned USA. Their researchers did a lot of this work and gave it to, I think it's George Pallas, a lawyer for Alan Fisher, with a case pending in D.C. And it's perhaps the most compelling document yet filed involving a change of venue. And so what is change of venue? In order for the court to hear a case against an individual, it has to have personal jurisdiction and subject matter jurisdiction. In other words, I can't be sued merely for being ugly. Ability. In other words, there's no subject matter jurisdiction. In order to have personal jurisdiction, you've got to reach the person. You've got to, and venue is a concept related to personal jurisdiction. The Sixth Amendment says that you must that a person has a right to be charged in the district and state in which the crime occurred. Now, the J6 defendants are typically being tried in D.C. Because that's where the J6 activity occurred. That's a horrible venue for defendants, because it's a very pro-government venue. And so lawyers in the J6 cases have struggled now for a couple of years to get these cases out of D.C. Imagine how different the Proud Boys trial would have looked in the verdict had it been tried in Iowa, where 51% of Republicans voted for Trump last night. In D.C., almost everybody votes for Democrats, and according to research done by Condemned USA and filed in court by George Pallas, people in D.C. are obsessed in their social media life by left-wing narratives about January 6th. When they're doing search terms, they're looking up white supremacy. When they're doing search terms, they're looking up mob-related action as to that day. They're not doing searches about Antifa. They're not doing searches about Black Lives Matter. They're not doing searches about deaths of despair. They're not doing searches about immigration. They're not doing searches about any of the other issues that might draw a candidate to Donald Trump or to the right. They're doing searches that endorse left-wing narratives, and the result is that they're saturated with information that make it almost impossible for the defendants to get a fair trial in that case. So Pallas has filed a motion reflecting this data. He's asked the court to change venue, and the government may or may not be worried about it. They've asked for additional time to respond. And one of the genius moves that Pallas did here is, and Condemned USA did, is they relied on some of the same methodology for searching jury pools that the government has used in other cases. Basically, saying when it had venue concerns, and it's basically said this government methodology suggests that my clients, that is J6 defendants, are not getting a fair trial in D.C., and maybe those trials should be moved to a different venue, to another location, because this jury pool is too biased, is too saturated with hostile information to provide people with a fair and impartial jury.
Yeah, I was looking at some of the slides that you sent over as well, Norm, and there are 6 key findings from one of the meltwater analyses that Condemned USA has used in supporting.
And tell people what a meltwater analysis is.
Well, I'll give it to you, but ultimately we're talking about saturation of various key search terms within the internet or Google Trends market, right? So pick a term like ice cream, for example, and they will look at what the baseline penetration of the use of ice cream is across 50 states and across the total geography of the United States. And then they will choose something that's lesser known or more localized, and they'll show the contrast between penetration within that smaller market, but broadly, basically nothingness across. So think of Hurricane Ian. And then with something such as Trump and J6, they will show that the trend or the statistics that underlie that penetration actually contradict the general rule, right? That is the ice cream versus the Hurricane Ian analysis with respect to an interest in a key search term such as J6 or President Trump. And what they're ultimately showing are using to support this motion to change venue are six things. So I'm just going to read these for our viewers. One is the quantity of media mentions in DC significantly and uniquely is higher than the rest of the country, that the media influence in DC is 82% higher than the US average, that local media in DC for the January 6 accounts for 51% of total media influence compared to 11% nationally. I'm going to reread that. Local media in DC for January 6th accounts for 51% of total media influence compared to 11% nationally. That's wild.
Yeah, it is.
He had significantly higher media influence across time. This continues through 2023. Every search term relating to January 6 shows that Washington, D.C. has a higher level of prominence than the U.S. as a whole, 57% higher. All
Mm.
comparison geographies have similar total media influence, except for Washington, D.C. So again, the motion to change venue is hinged to this notion of implicit bias, which I have a sort of an aversion to in general. We talk about implicit bias in other contexts, such as DIE now, but DEI and sort of ESG, all these in Black Lives Matter, blah blah blah. But this is being used in a much different way to show that the DC jury pool has no autonomy with respect, on average, with respect to the coverage of J6 media, and therefore the conclusions reached and the likely hill that any sort of defense counsel and defense team would have to overcome in a routine prosecution of cases under J6.
So, for those of you who have a little bit of extra time on your hand today, read Sonia Sotomayor's dissent in the Jeff Skilling case arising out of the Enron prosecutions in Houston. She dissented and claimed that the media saturation in Houston made it impossible for Jeff to get a fair trial in Houston, and she would have granted the motion for a change of venue. I think there has to come a point where media saturation just matters, and notwithstanding what jurors say, the climate of opinion, the environment in which a case is tried can be drenched in such hostility that there's really no harm in moving the case. It might inspire public confidence in the outcome, and I would suggest that in the J6 context. If these cases had been spread around the country, tried in Knoxville, Dallas, Sacramento, Seattle, Tacoma, Billings, Montana, if you just randomly sorted them out around the country and tried them there, we might have different results. But if we had the same results, I think there'd be a lot more public confidence in the outcome. We're getting our balls broken by Junior Coltrane today. We're emotional thinkers, and therefore, we're not to be trusted. And I can't even utter Donald Trump's name without a certain sense of revulsion. Junior, bottom line is, I wouldn't go to lunch with Donald Trump, even if he offered to pay my transportation to an exotic location and have lunch with him. But if I was in a polling place today, I'd vote for him. I'd vote for him because I think that he's got the attitude that I want for a person in the White House, even if I don't like the guy. But as for my emotions, I remind you, Mr. Coltrane, of David Hume's classic line written in the 18th century: reason is and always shall be the slave of the passions, and my reason is the slave of my passions. I am an embodied intellect, as anybody is, and this is one of the challenges with respect to AI. You can have disembodied logic, but unless it's embodied and experiences the world and the manifold of experience, it's useless. And so, Junior, if you're looking for a better quality of podcast, we invite you to go elsewhere. We can only offer what we have, but we can't satisfy every swine before whom we cast our pearls. So, Mike, where can people find us if
Wait,
like
Julian.
Junior?
Good morning from down under. Julian, he asks, if the court accepts the change of venue motion, would this endanger the security of past prosecutions and convictions?
Well, would it endanger? So let's talk a little bit about how you develop a record on appeal. Um, when you go to trial, a trial obviously is in theory, a search for the truth. And you've got the United States government in a criminal trial, a federal criminal trial. You've got the United States government against a defendant, and both sides have representation, presumably, and in almost every case they do. And the defendant is charged with substantive offenses, and there are procedural rules and rules of evidence that govern how the parties are to behave in the presence of a fact finder, in particular a juror or jury, and what evidence is or isn't admissible. And so the participants in the trial, the lawyers, work to develop a record. And that record consists of all the documents filed in the case, the court's rulings, and the testimony heard and the argument made. Once the case goes to verdict and a verdict is accepted and a judgment enters, the record is closed. There can be post-trial motions that occur prior to judgment, but once a record is closed, then the case goes up on appeal. And the appellate record, the items that an appellate court can consider on a direct appeal, that is an appeal from the judgment of conviction, is confined to what's in the record. So the answer to your question, Julian, is the defendants who've raised change of venue motions might be able to try to incorporate some of this stuff into their into their appellate records, but it might be difficult because if there are additional facts, considerations, and theories that didn't make that record, the appellate court might feel obliged not to hear it. There is, however, a second form of post-conviction relief, and that's called habeas corpus. And habeas corpus, Latin term, you have the body. You're holding a person in confinement unlawfully. So if a change of venue motion succeeded in a subsequent case where maybe the prior trial lawyer didn't raise it or raised it on different grounds, such that the subsequent material is not part of the earlier record, that defendant might be able to argue that his trial lawyer was ineffective within the meaning of the Sixth Amendment. In other words, the Sixth Amendment gives you a right to counsel. The Supreme Court has declared that that's not just somebody asleep at the table in most cases, but it's the right to an effective lawyer. Or you might be able to argue that there are due process cases or reasons for considering this new information. So I think, Julian, the answer is that, if the court grants a change of venue in a subsequent case, it's going to create a lot of ripple effects in earlier cases, but there won't be automatic reversals.
Yeah, and it may create ripple effects in particular because, Norm, I think you know this as well as anyone does, the theory upon which a change of venue is based, even if different data or a different approach or a different theory is used here, in general, the change of venue has been something that has been, volleyed back and forth by various counsel for the defendants over the last couple of years, right? It was one of the key features in the Proud Boys prosecutions early on. That was something of, are all of these defendants going to be prosecuted in an environment like the District of Columbia, right? That was one of the very first issues that were dealt with, and I believe, the Oath Keepers was the same thing. Everybody has some intuition, albeit without the data to support or the narrative backed by the data to support a compelling reason to change venue, but it's been there from the jump. So I suspect that the question is the right one to ask because it's sort of a logical extension of what the public would begin to wonder if there is one granting of a motion for change of venue.
Yeah, no, it's an interesting question. And it's a I give George Pallas a lot of credit, and I give the folks who condemned USA a lot of credit for staying on this issue. Don't know where it's headed, but I do say stay tuned. I mean, to wrap this segment of it up and maybe this show, stay tuned. I have a hunch within 30 days. There's likely to be some significant new J6 prosecutions. And what that will reflect is the Justice Department's frustration to advance its cases against Donald Trump, its desire to bring down Trump as a candidacy, and its effort to prove through missing middle links, Roger Stone and company, that Trump was behind it all after all.
You can find us here on X at LawPod Daily. Same thing on YouTube. We're Law and Legitimacy on Rumble. You can also find us on Apple Podcasts, Spotify, Google Play, Overcast, wherever you find premium podcasts. The audio only is uploaded every day after each day's streams conclude. Please also give lawpoddaily.com a visit. Subscribe to our newsletter. Newsletter number 1 went out yesterday, 7:45 a.m. We're working out some kinks, so thank you all for the patience there. But things are starting.
We've got kink in the newsletter. Whoa! I can't wait to read it.
Only one that we're working out. Anyway,
Annie in Heels, the true expose.
Yeah. So thank you all for your patience. Things seem to be coming together quite nicely for us right now. We're going to keep at it, keep chipping away. And again, if you have not liked the video that you are watching right now, please make sure you're subscribed, and if you're feeling generous, share it. Norm, thank you for your thoughts today on what will be a really interesting season now that we have concluded the first caucus. The criminal prosecution side is going to ramp up again from the DOJ. So anyway,
what a
thank
wild
you all.
ride we're going to have this year.
Yeah, thank you for everybody on Rumble, and thank you for everybody on YouTube. Nobody in particular, but it's been active in the last couple of weeks, so I appreciate that. Norm, anything else?
Nope. Hi, Mom. Now, guys, you're thinking, isn't that cute? She's been dead for 5 years, but she still might be watching. Talk to you tomorrow.
See you later, everybody. Thank you.